Welcome to Our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hi, and welcome to Our Curious Amalgam. My name is John Roberti. Our topic today is, what is the secret sauce behind developing a complaint? We've noticed a slowdown in the enforcement of the federal antitrust laws by the federal agencies. But what we've also seen is private litigation continues to go strong. What we believe is that this suggests that private enforcement will be playing a significant role, an important role. And we wanted to explore today how private lawyers bringing actions on behalf of plaintiffs develop their cases. My co-host today is Sergei Zaslavsky. Hi, Sergei.
Hi, John.
Sergei, what do you have lined up today?
Sure. Today we're going to learn a little bit more about how plaintiffs develop and bring their complaints. I think there is a perception in the antitrust world that private firms mostly just coast in the wake of government investigations. And while that is sometimes the case, that's certainly not the only way in which plaintiff firms bring complaints. So we're going to peek behind the curtain and learn a little bit more today about how the process of developing a complaint works.
And who's our guest today?
We're very lucky to have Melinda Coolidge today with us. She's a partner at the Housefield firm, which, as folks know, is one of the leading plaintiffs firms in the country. And she is also the vice chair of the ABA Antitrust Section's International Cartel Task Force.
And Sergei, what are we hoping to get out of the conversation today?
We're really trying to get some insight into private antitrust enforcement. Of course, government enforcement plays a big role, but private enforcement is playing an increasingly important role as well. And that all starts with developing a complaint, figuring out how to bring a case. And that's the process we're going to examine today.
Well, let's bring in our guest. Melinda Coolidge, welcome to the show.
Thanks for having me.
Melinda, great to have you with us. How are you?
Doing well, thanks.
Tell us about some of the ways that you as a plaintiff's lawyer find a case for which you might file a complaint.
Well, some ways you wouldn't be surprised of if the Department of Justice announces an investigation, the European Commission announces an investigation, but some would probably surprise you. One of the best examples I have is in China, several vitamin C manufacturers announced on their websites that they had agreed to limit supply and set minimum prices for vitamin C. And public announcement, not sure why they did that, but because they sell directly into the United States, that was immediately flagged for us that was a price-fixing violation and violating U.S. antitrust laws, and we sued them there.
What were you doing checking the website of the Chinese vitamin C manufacturers?
I can't disclose that.
Was there a press release that came out after that? How'd you figure out where to look?
To be honest, I don't remember that one, exactly what happened, but I do have Google alerts set for a number of keywords that would flag things for me.
I bet defense lawyers would love to know that list of keywords so they can advise people accordingly.
It's not rocket science. You'd be surprised what people say when they're not thinking.
So it sounds like that one was kind of brought to you on a silver platter. Is that more common with foreign companies? Do you find that U.S. companies still more difficult to find something that the company puts out itself that gives you the crumb trail?
It is pretty unusual to have someone announce that they're price fixing. We look at annual reports, we look at news releases, we have people just call us and say, I'm seeing prices go up, like what's going on? There's a lot of different ways that these things may come to our attention.
And once something does pop up in your radar, what kind of diligence do you have to do in order to determine whether there's an actual complaint there that's worth filing or not?
Well, we do quite a bit because we don't file unless we are planning to invest in a case for 5 to 10 years. So that's a big investment. We're going to make sure we know what we're getting into. So we research everything that we can that's publicly available. We scour the internet. We look at industry reports. We talk to industry insiders. Sometimes we hire economists. And we make sure that we know the ins and outs of the industry and that we've seen actual price effects before we file.
How common is it to hire an economist early on? It seems very early in the case, to even before the complaint is filed. Is that something that you find useful frequently?
It depends on the industry. If we can look at prices, if prices are publicly available and we see price increases over time, we may not need to do it that early. If there's no pricing information available, or sometimes you even see downward trends, and so you need an economist to look at other factors that might have been playing into what the prices were. We don't do it every time, and we don't necessarily use the same economist throughout the case as we would before, but we do it every so often.
You mentioned price effects, and you focus on price effects. One of the big topics in antitrust recently is that maybe the antitrust law looks too narrowly at price effects, and there are other types of consumer harms that are worth of consideration. Is that something that's percolated into the private plaintiffs bar as well? Are you starting to look at other types of effects?
I can tell you we're looking at it quite deeply. It goes back to this point about being willing to invest in a case. And we want to make sure that we're going to be able to prove some kind of monetary damages prior to investment, or know how else we're going to recover for that case. So I can tell you we are looking across the board at effects to innovation and other non-price effects. And you'll probably see some cases coming out.
It's just a little more difficult to get the science behind that right, because it's not as well developed as the price effects.
Yeah, I don't know if it's the science so much as the case law. There just isn't a lot of developed case law on it, and so it's more difficult to predict what's going to happen.
That makes sense. Tell us, what is the fastest you've ever gone from an idea for a complaint to an actual complaint being filed?
Probably a couple days.
Wow.
We know how to act fast, and we know how to drop everything to make sure we're right on top of whether it's, if it's something like a guilty plea where, a company specifies, or the DOJ specifies in its press release about the guilty plea what the company is, what they did, what product, who else is in the industry. It's not that difficult, right, to put together a complaint that would survive a motion to dismiss.
What's the more usual timeline if you don't have the government kind of having done all the work for you already and you have to investigate the case? How long does that usually take?
Well, first I'd say getting a guilty plea is not the government doing all the work for us.
I'm sorry for that characterization.
There's still plenty of work that we need to do. But, if it's not government instigated, we're talking much longer, probably weeks or months that we're looking into something.
How many ideas that you have end up on the cutting room floor?
Probably 75%.
And I assume that's at various stages of investment.
That's right. We do our best to be very efficient in our analyses so that we're not investing for months prior to putting it on the cutting room floor. But it does happen.
What's the most common reason something ends up on the cutting room floor?
Just not enough to substantiate it. I couldn't point to one thing, whether it's, lack of evidence of illegal conduct, or whether it's lack of evidence of price effect. It could be any of those.
So when you're pleading antitrust conspiracy, which element is it most difficult to find factual support for without having the benefit of discovery?
Well, you could say conspiracy, but you don't need to have direct evidence of a conspiracy to survive a motion to dismiss, and you usually don't have that.
The circumstantial evidence and plus factors route.
Exactly. So I'm not sure I could identify something that would prevent us from moving forward with the case.
Do you see the trend towards more cases where private firms are developing their own cases, and there's really not a government investigation in the background, or do you see that as expanding?
Yeah, perhaps as a very long-term trend. We are often bringing cases the government hasn't brought. We have a huge case pending against all of the Blue Cross Blue Shield entities. in which, people may not be aware, but Anthem and Primera and Care First and Highmark are all they're all members of the Blue Cross Blue Shield Association. And they have agreed amongst each other not to compete. And that is exactly what the antitrust laws are designed to prevent. Businesses that should be competing agreeing not to compete. And we brought that case, I want to say 5 years ago, and it's still going strong without the government coming in. We've also filed cases first that the government follows us into. Our dental supplies price fixing case, which was against several distributors of dental supplies, and the government came in after we developed that case.
Is it helpful to you, or does it slow you down if the government comes in after?
It depends. It never hurts in the long run, right, to have the government, in there saying someone needs to stop this conduct. But if it follows us having already found the evidence we need, and then sometimes it can result in stays. I don't think it did in that case. But obviously that slows us down if the case is stayed during a government investigation.
Now, you've been doing this for a while. What kind of trends are you seeing in standards for getting past a motion to dismiss in terms of how courts rule on motions to dismiss?
Yeah, there was a lot of noise made around Twombly and Iqbal. Maybe it was about 8 years ago. And it's certainly the case that complaints are now longer, right? I think that complaints used to be about 10 to 12 pages. I cannot remember the last time we filed a complaint that was shorter than 30 pages, and we've got 95-page complaints out there. It just means we are including everything that is relevant in order to provide enough support for the allegations to defeat a motion to dismiss. In at least the complaints that my firm has filed, I don't think that we've seen a higher rate of dismissal. Most of our cases make it past the motion to dismiss for the reasons that I was expressing before.
So I think when you said before 8 or 9 years ago, there was a lot of talk about this. I think there was a pendulum you had the Twombly and the Iqbal decisions, and it swung one way. And now I think it's probably swung back the other way, and now we've sort of achieved an equilibrium. I'm not sure. I'm not sure the standards are gonna change all that much. I think. What do you think?
I agree. I don't really see them changing. It's really just about making sure you're meeting them, which we can usually do, right? I mean, the federal rule, it doesn't actually require that much, and we try to go way above and beyond that.
Do you see your firm putting more time to develop a complaint and perhaps leaving more on the cutting room floor as a result of the change in standards?
Yeah, definitely.
It's a longer process now?
It's definitely a longer process. And like I said, we're really making sure that we understand the whole industry before we're filing, and not just saying, oh, there's a guilty plea. Conduct.
Yeah.
So one of the things I've noticed as well is that there are more firms that are specialized antitrust firms. I think in the past you could say, take an example. You read about a grand jury subpoena or a guilty plea. It doesn't require a tremendous amount of antitrust experience in order to drive that case forward. What I'm seeing, I believe, is more firms that are really developing an antitrust expertise, and they tend to be the ones that are getting the lead counsel roles. Is that a trend you see as well, or do you still see new firms entering who have made a name in securities or another area of law?
No, it's true. You do tend to have more what we call copycat complaints when you've got guilty pleas. So firms that do a lot of other things, jumping in and saying, me too. I have a client that suffered from that conduct as well. I don't know how many firms are focusing on antitrust. It does seem like just a handful, of which my firm is one of them. And because we spend our whole day thinking antitrust, when we read the newspaper, we see antitrust. And when we talk to friends, we see antitrust. And it helps us focus and develop those cases.
It seems that recently there's been a lot of talk about the intersection between antitrust and privacy and data. Is that something that's being reflected in the way firms such as yours think about potential cases as well? Or is that something that you're kind of taking a wait-and-see approach? Let's see where it shakes out with government policy, and then we'll see the best way to play that.
Well, I'm just trying to think the intersection that you're referring to, if it's like the Facebook, Google. I think we are certainly looking at how privacy and antitrust intersect in that sphere. My firm also has several cases about data breaches, but those aren't really...
Not as antitrust related.
Correct.
That makes sense.
Yeah.
Well, as you think about bringing a case, do you ever think about the international implications? I mean,
always.
Your firm has opened up in Europe. Mm-hmm. When you're developing the case, is there coordination across the pond? Yes.
We are very diligent in ensuring that we are sharing all public information with each other. It tends to happen more often than not that something is focused on a particular, just in the examples I can think of, they have tended to be focused on a particular country, or at least either U.S. or several countries in Europe. But we have certainly seen that bleed with worldwide industries like air cargo. I'm trying to think of some others that did overlap. I mean, one thing we did recently was file a case about price fixing of salmon based on a European Commission investigation. There were some raids in Europe, and we filed here in the U.S. So we are always trying to make sure that we're not leaving somebody out who could be recovering.
Melinda, it's obvious that you love practicing antitrust law. It's obvious that you love being on the plaintiff side of the bar. Tell us why. I mean, what drives you? Why do you love what you do?
Well, I went to law school to help people, like a lot of folks who went to law school.
So did I, but
So it makes me feel good when we are able to recover for the victims of wrongdoing. And I think it's a really important part of the private enforcement of the antitrust laws. The Department of Justice is there. They send wrongdoers to jail. They collect criminal fines that go in government coffers, but they don't collect for the victims of anti-competitive conduct. So whether it's businesses that paid too much or it's individuals that paid too much, I am proud to be working to get money back to the right people and protect a free economy.
All right. Well, Linda, let's find out maybe a little bit more about you. Can you tell us something surprising or unusual about yourself?
I don't know how unusual it is, but I love to travel. I've been to dozens of countries, and I'm one of those people that actually takes vacation.
Now, how many stamps are in your passport right now?
I had to get a new passport because I ran out of pages.
Really? Do you have global entry?
Yes.
Well worth it. Okay, well, now we're going to move on to the final segment of our show, which we call the Curious Hat.
And now it's time for the Curious Hat.
Linda, this is the time in the show where we've got a number of questions here, and I have a hat. And so we ask you to pick a question, any question. I'll read it, and then I have a follow-up question that'll come on the back of that.
Picking question I can't see. Scary.
Okay, this is a good one. What is your favorite guilty pleasure novel? What is your favorite novel and why?
I just read A Gentleman in Moscow, and I absolutely loved it. I bought a bunch of copies and handed them out to my friends. I love novels that take me to a foreign place, hence the love of travel, and particularly if it takes me to a different time and really puts me in the shoes of somebody else, and I can go exploring someone else's world.
Well, that will do it. Melinda, thanks for coming. That's our show. We will see you next time.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by the ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent those of their employer or other organization. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org antitrust. If you have suggestions for topics or are interested in participating in a future episode, please reach out to us at ourcuriousamalgam@americanbar.org. Until next time, thank you for listening.